example, $35,000, almost $36,000 that didn't need to be paid if the claims had been either avoided or reduced as far as the amount that was paid. So we get to the modified premium. The next step, which is why it's highlighted, is another area where employers can have impact to help themselves reduce their costs. Where I'm showing carrier credit, there's all different names for these, but basically they're internal credits that each carrier has. They file them with the state of California. They're discretionary, and they can apply them for any number of reasons. Sometimes it's to offset a 150X mod because they're the new carrier on the account. They didn't have to pay for those claims. They feel that they want to gain the business, so they put on a credit that offsets, mitigates, or completely offsets that penalty, and other reasons that we'll get into a little bit later as well. Then every company has a premium discount. Basically what that is the volume discount. The bigger the premium, kind of the economies of scale come into play, and you'll get just an automatic credit from all carriers. So that's kind of the formula that they go through. At the end of the day, when you're audited, this is what the auditor from the carrier is going to do once they have your actual payroll next year. They'll go through this process.
So obviously clerical is a lot lower because paper cuts don't cost as much as machinery dropping on people's heads.
Correct.
Okay, so now the question is, what's fraud and what's abuse? Every time I have an employer and we talk about work comp, they go, God, my employees are committing fraud and they're trying to steal from me, and what's the difference?
I understand why they feel that way. I've sat in so many claims reviews and literally felt the same way as I've listened to the things that are happening to my clients and to employers in general. But the key thing to remember is that fraud is an actual crime. It's a civil crime where abusing the system, whether it's an employee, an attorney, a medical provider, is not a crime. And so when it may be semantics, but when you perceive a claim or call a claim a fraudulent claim, you have to be kind of careful about that, because odds are most of those claims that you think are fraud are in fact abusive claims. And so the bar, if you will, the legal bar, and I'm not an attorney, but there's 5 standards or 5 things that need to occur for fraud to be committed, and each of those, not some of them, but every single one of those has to be able to be proved in a courtroom by the district attorney's office before they can convict your employee of committing fraud against you. So again, maybe we shouldn't go into this in too much detail, but it's got to be a knowing act. They have to essentially be consciously committing a crime and stealing money. They have to essentially trick the carrier or the third-party administrator into believing that what they're saying is true, or the documents that they're providing are legitimate. And then the carrier has to rely on those to make payment that shouldn't be made. And that in turn results in the damage to the employer, financial damage to the employer or the insurance company. Any one of those pieces isn't able to be proven beyond reasonable doubt, you don't have a fraud case.
Okay, so we have 3 types of claims now: legitimate, abusive, and fraudulent. And from what I just gathered, fraudulent would be very hard to prove, and it doesn't happen very often, but abusive does. So let's talk about legitimate, abusive, and fraudulent claims.
So legitimate claims, most employers have seen these before. The workers on the job site, they have an injury that's visible, cut, finger, a burn, something in their eye, that sort of thing. Other employees or their supervisor witness what happened, so we know it's work related. The injuries immediately treated by the company or the insurance company's selected physician at the industrial care clinic. They produce medical information that makes or leads the carrier and the employer to accept the claim as work related. The employee is given a treatment program that they actively participate in on a timely basis, and their goal is to come back to work. It's kind of classic legitimate workers' comp claim. An abusive claim gets a little bit different. So usually what we see in these things is while there may be an injury, We don't know where that injury occurred. Sometimes it happened at home and the employee doesn't report it until several days later. Usually it's a soft tissue injury. It's not a cut or something that's able to be seen. So strained back, strained shoulder. Very often it happens in a place where, again, no one saw it, there's no witnesses. So in abusive cases, very often the employer kind of gets a feeling that there's going to be a problem. They explain that to the adjuster, or you explain that to the adjuster, and there's a 30-day period that the carrier can either accept or deny the claim as work-related and compensable. So on these abusive claims, you usually find that that window is opened, and there's a 30-day period where they're scrutinizing whether or not this is a legitimate claim. If they accept it, very often these claims, the employee is less than compliant. They try, they're malingering, they're trying to get out of work, they're really just in no hurry to come back to work. And then fraudulent, we just went through this kind of a quick example. It's the employee sets the stage, you catch it on film, and engages an attorney who helps him collude with doctors to steal from the insurance company.
So we have some examples of employee fraud, and we just talked about some of them. Filing a claim that's not work-related to get a financial gain, lying about an incident, colluding with attorney doctors. Paul just mentioned that. So we'll go through this one. But let's talk about medical fraud a little bit, because I know that there's a lot of abuse in the medical system, healthcare system. But how is medical fraud applied to workers' comp?
So we're kind of back to that definition, that legal definition of fraud. If a medical provider is doing all those things, they're intentionally trying to steal money from the insurance carrier or the third-party administrator, that's fraud. If they are charging too much for the services they provide, providing too many services, maybe going beyond what they would normally do for somebody who just walked in off the street with the same injury, that's actually medical abuse. All right, so fraud would be something like billing for an examination of a patient that they never actually did, billing for treatment that was never rendered, sending duplicate bills to carriers or to multiple carriers and trying to get payment from various sources for the same treatment that they did render and knowingly doing that, those types of things.
So let me ask a question on the last bullet point. It says misrepresenting the true ICD code, and I have no idea what ICD means.
So in the medical world, there is a formal coding system used for each type of treatment rendered. I believe today it's, I think it's ICD-9. So they're actually dictated by the federal government. And if you accidentally put in the wrong code, you can get a higher reimbursement from the carrier than you would if you put in the actual code. So if they're, again, knowingly doing that, so let's say, for instance, you have a facility that for every person who comes in and has their elbow put in ice water, and they're billing for an hour of physical therapy, doing something else, and they code it that way, incorrectly, and it goes out all day long, every day, as a matter of kind of company.
That would be fraud.
Directive. That would be fraud.
Okay. So we have a slide about ancillary services, but I'm not sure what that exactly means. So
yeah. So real quick, when there's a workers' comp claim, it's not always just medical and wage reimbursement. There's very often a need for people like translators or delivery services, copy services, that kind of thing. So those are the ancillary providers to a workers' comp claim. Some of the things, fraud and abuse, that you might see with them is an attorney may bring in an interpreter for an employee who clearly has English as the first language. That interpreter charges triple what they would normally charge, with the idea that when the claim settles, they're going to get paid for something that really didn't need to be done in the first place, so on and so forth. So
okay.
Again, this slide can be quite long.
So how do we fight fraud and abuse today?
Okay, so the first thing I tell employers is it's always helpful for everybody to kind of have a game plan and to acknowledge, why is it that the company, the employer, wants to really fight a particular claim or fight any claim that they see as abusive or fraudulent. So there's various goals and purposes for doing that. In some cases, it may just purely be cost reduction. That if we work with our carrier to help them understand that the person is taking advantage of the system, we can get the reserves reduced, we can get the final settlement that's made to be less, and that translates to a lower premium for us. If that's your goal, that's one thing. If you also want to add into the deterrence factor, that you want to make sure other employees know that the company's position is any claim that is either fraud or fraud-like, or people who go out with legit claims, malinger or embellish their claims, that the company is going to fight back and do everything they can to make it uncomfortable for that employee, with the idea that other workers who might have the same idea would be have second thoughts about it. That could be another possible goal. Sometimes it's just an owner who's so angry at the situation that they just want to fight it on principle, or that they want to do everything they can to make the employee's life as miserable as possible within the scope of what the law allows. And if your ultimate goal is conviction in looking at a fraud case, then again, you got to go back to that reality of what do we need to do? What's the standards we have to meet to get a conviction? And if we don't, be willing to step back and let it go, basically. So, so back to fighting fraud. Every employer, whenever there's an accident or a near miss, even at their company, should have a formal accident investigation plan in place. And that's again another kind of topic, but it's a system basically, and it should be used in all cases, because if somebody has a near miss, you don't want the next one to be somebody who loses a hand or whatever, but you also want to set the stage or possibly uncover the potential for an employee committing fraud or abusing the system. So you want to do interviews of the witnesses. You want to take pictures of the area that the injury occurred, so on and so forth. So the other thing is you should engage your claims adjuster if you suspect fraud. Let them know that as soon as possible, because they will handle the claim differently. It'll kind of rise to the top of the pile. They'll be more apt to take your telephone calls on a quick basis. They'll even coach you as to what you might want to do to kind of dig a little further, or to validate your suspicions about what's going on possibly. Again, there's a lot of things that can be done, but this is kind of those are the big kind of 40,000 foot things that all employers should be doing.
Having said that, we talked about fraud, and now we talk about investigation.
Right.
And I know we have a couple slides on investigation. I guess I'll go back to the last one. But tell me about what type of investigation needs to be done.
Okay, so as I said earlier, employers should not be afraid to do accident investigations. It's something that, again, is for the benefit not only of the injured worker, but also of the coworkers, of your other employees, so that they don't have similar injuries occurring when something isn't corrected. It's a dangerous circumstance. So there should always be that investigation done. And if that investigation starts to uncover things that make the case appear that it might be a little bit, doesn't pass the sniff test a little, it is okay to dig deeper within reason. And back to, if you talk to the carrier, to your adjuster, they very often can kind of coach you as to what you should and shouldn't do, where you can go, where you can't go, that sort of thing. And then you can follow up as a team to further that accident investigation. If you get to a point where you really believe that it's a potential fraud case, or that it's a case that's going to become embellished, some adjusters are reluctant or in some cases don't even think to push the case over to their SIU, which is their Special Investigation Unit, for further investigation. So you as the employer should always ask them to do that. If you need to, you should push them to do that. And what I mean by that is there's been times where I've asked by my clients to get on the phone with the claims manager and get them to make the decision and you know, supersede maybe what the adjuster didn't want to do to get it over to the SIU. So, you know, make a concerted effort. Don't just assume it's going to happen because they're on your side, basically.
So I have a client that owns 6 or 7 locations in the LA area, and he had a work comp thing, and he wanted to start doing investigation himself. He wanted an employee to kind of, you know, watch that employee and follow him after work. And I said, hey, you know, you better not do that. But you say you shouldn't become the lead investigator. So what do you mean by that?
Right. So you're the person who is the initial investigator, and then you again partner with the claims adjuster who becomes another partner in your investigation. But there's a point where you need to let go of the case for various reasons, separation between the employer and the employee in that relationship, and let a trained professional take the lead, and they may actually ask you to become involved and still be part of that investigation process, but they then become the quarterback and the responsible party, and they work for the insurance company, not for you, the employer. Okay, so they know what they're doing. They know how to work directly with the claims examiner, as well as if you have a litigated case, the legal, it's usually not a team, it's usually the attorney that's assigned to that particular case. They communicate, essentially they talk the same language. In some cases they coordinate, you know, go get this or go find, you know, go see what's going on here. So the other thing real quick on the surveillance is that, you know, when you videotape people, when you have people follow people around, that kind of thing, there's the right to privacy that your employee has that you really need, I think, just need to be aware of, and also acknowledge and accept that you wouldn't want somebody necessarily following you kind of into the bathroom kind of thing just because they thought you were doing something wrong. So, you know, I think just from a purely humanitarian standpoint, stepping back a little bit makes a lot of sense. The other thing is, I have a lot of, probably your friend, if they do get video of somebody, let's say, taking the trash cans out when they, you know, they aren't supposed to be able to work and so on, they think that's kind of the key that's going to turn the case, and it's all going to go away, and they're either going to get arrested or their attorney's going to drop the case. And that's not what happens. In most cases, it's just a piece of evidence that a good attorney is going to work around and either diminish when it comes to negotiating a settlement or if they're in front of a judge. So it serves a purpose, but it doesn't. Videotaping of an employee doing certain activities almost never causes the claim to go away.
Okay. You talked about Special Investigation Unit and looking at abuse and fraud. Is there anything you want to add about what SIU does?
Yeah, I think the key thing too, back to beyond being professionals, you know, many of them have law enforcement background, they've been doing it for a very long time, is the fact that their function or their purpose is, first of all, they always work for the insurance company. They may hire people outside to do the videotaping, you know, the oversight, but the SIU people work for the insurance company. Each carrier has to have an SIU unit, and their purpose is to find the truth. They're fact finders. They're not there to win the case for the insurance company and you. They're there to find out what really happened. They review as many records as are pertinent. So if you have information that you can provide through the adjuster that would help them in finding the truth, then you should provide those. I'll give you a quick example. I had a client that found out that one of their injured workers who was on temporary disability, was not supposed to be doing anything but staying at home. I don't know what this guy was thinking, but the injured worker took a job at an employer literally across the street from their old employer. And you know, it became evident they were seeing friends, you know, in the parking lot and so on and so forth, who came back to my employer and said, hey, you know, Bob's working right across the street here. I thought he was supposed to be out on workers' comp. I'm covering for him right now, so on and so forth. So they went, reported that to the adjuster. The SIU people subpoenaed the payroll records of the other company, and the guy actually used back here's fraud, used a fake social security number in someone else's name to get that job, and but they were able to find that out. The SIU person would have never known about that had the employer not told them about that and had those records not been there. So
That's an amazing story. It reminds me of a company in Sylmar that I used to be banking when I was in my banking career. They made airplane windows, and across the street there was another company that made airplane windows, and down the block there was a third company that made airplane windows. So hopefully it's not the same group of people.
no, this was up in Ventura County.
Okay.
So one more quick thing just on that part is employers need to be prepared too, and it does happen, that when the SIU people start digging, they find out that there's evidence that either exonerates the employee completely or would tend to if it went in front of a judge. So be prepared that you may not necessarily like what they find, but again, their function is to find out what the truth is. And so they put it all up on the table, whatever it is.
Okay, so now we talk about why employees cheat. And we have a couple slides on this, so I'm going to let you take over.
Yeah, so I said to you earlier, I said, how long do we have to this webinar? Because this list could go on for about 4 pages. So I'm going to kind of try to hit on some of the ones that I find to be most often the reason. And what I don't find is that I don't find, well, it does happen. The motivation isn't necessarily that the employee doesn't, they want to retire kind of thing off of this injury. What I do find is that very often employees, especially low wage earners, they don't understand how our workers' compensation system works. They think it's like auto insurance, and that if they file a claim, the employer is going to put the claim into the insurance company pays all the bills, and therefore, if they embellish the claim or use it to get a big settlement, that they're not hurting the employer or anyone else that they know. It's the insurance, it's kind of the big bad rich insurance company that's taking the hit. In reality, most employers know, and I'm sure you know this, that insurance companies have a way through the XNOD system, through taking away some of those discretionary credits that we talked about previously, of getting their money back. Right. So over the next 4 years after a claim is filed, the employer pays most of it in nearly all cases, and then they've got to recover that cost. And usually often that can happen by not giving raises, or not offering as many benefits, or not having a company Christmas party, whatever it is. And so it trickles down to their coworkers. Mm-hmm. If they understand that, and that's something that the employer, that's one measure an employer can take to do that. We find that it doesn't prevent those types of claims, but people are reluctant, and they've told us that they just didn't want to kind of hurt their employer because they like the employer in some cases. Mm-hmm. All right. A lot of times, if somebody has been, in particular, has been put on a probation or a work improvement program, just been disciplined, maybe a second time, and you have a 3 strikes disciplinary policy, it's a preemptive strike by them. So they'll stage or invent an injury because they feel that it gives them some protection or some leverage against what ultimately might happen, which is usually their discharge or demotion. The other thing that, and everybody knows this, but just to put it out there, people are hammered by attorneys, by messages on billboards, advertisements on TV, that if you're injured on the job, you need representation, and if you get a good attorney, they're going to get you, riches beyond your wildest dreams, and you'll be able to be wealthy and not have to work anymore. Whatever the promise is that they give to the employee, And in some cases, those people, again, especially if they're low wage earners, they believe it. So, and also there's kind of a scale there. If you're somebody making $30,000 a year, and they tell you they can get you $25,000 for your claim, that's a lot of money. That's almost a year's income. So you're going to listen, right? Another one we find a lot of times is when you have a tyrannical boss or somebody who's very cheap or just doesn't care about their employees, it's a get back. It's it's a way for them to take a strike, and that goes back to a lot of these claims, or many of them are self-inflicted by the employer. So from there, there's, again, the list goes on and on.
We have some more lists here. No individual health insurance for personal injuries.
Yeah, that's a good, so there's a crossover between what you and I do, Barry. What we're now seeing in many cases is when it used to be that we would tell employers to offer, or encourage them to offer group health insurance with the idea that if the employee was on the group health plan and they were injured away from work, they would have a way to have that medical cost taken care of by an insurance company, or at least most of it. And that would then lead to them filing less what we call Monday morning injuries, which would translate to lower premiums on your workers' comp and almost subsidize your health plan. That's all still true to a degree, but what we're seeing now is with the higher deductible plans that are being offered, even on the HMO side, higher co-pays, so on and so forth, that a lot of employees, the cost of utilization for their health plan almost makes it prohibitive for a serious injury or what might be a serious injury. So they're still choosing to report those Monday morning injuries and run that injury, even if, again, a legitimate injury, through the workers' comp system. So I don't have an answer for that right now, other than maybe an employer kind of doing an evaluation as to where the kind of the line is and looking for plans that are more user friendly. But that is something that's out there that employers should be aware of as well as yourself.
All right, let's move on to talking about abuse and some of the highlights on, it says be prepared to be abused, which means that as an employer, you're going to have abuse and you have to just understand that.
Yeah, well, I was mentioning that when I put the slide together, I had the voice of Foxworthy, who's a comedian, in the back of my head, and his shtick was basically that if you have certain things happen, or if you do certain things, that you just may be a redneck. So in this case, it's if you see any of these things, if you hear about any of these things, if you experience anything of these things, you may be abused. You may be, unfortunately, in a position where bad things are going to happen. So the clear one that we always know is a problem is when the first notice of injury doesn't come from the employee, it shows up in the mail from an attorney's office. So instant red flag that you need to get on the phone to the claims adjuster as you're filing that claim and tell them it's going to be a problem, and ask them to get it to an adjuster quickly, and to an adjuster who works on larger claims.
Okay.
So if you have an employee, back to that, who's on work, who's a poor work performer and who's on a performance improvement plan or disciplinary plan, or on probation, and you can tell they're not happy about it, odds are there's a good chance you're going to have a workers' comp claim suddenly happen, especially if you terminate them, which is basically refer back to number one. You'll probably get notice from their attorney.
Yes.
Okay. The other is if your workers have had multiple friends and family file claims, and in particular, if any of them have received a settlement. Back to my comment earlier that if a low wage earner has a cousin who gets a settlement for $25,000, even if they don't realize that $25,000 because the attorney takes some of it, they hear that number, and all of a sudden it's, hey, if he did it and was successful at it, I ought to do it too. So a lot of my clients have multiple family members working there, and again, we see this happen fairly frequently.
Yeah, the coworker thing I've seen a lot. I have a company out in Ontario, and I've gone up for 35 years, and they had a worker in the cut and sew operation get injured, and all of a sudden, 2 or 3 other workers within a week or two got injured also, supposedly same attorney, same medical group, etc. So obviously they saw their friend did it, so they decided to do it too.
Right. So when you see, and there's another kind of red flag, if you do receive that first notice from an attorney and it's the same attorney several times, then you really have a problem. Beyond just a single bad claim, you're going to have, a cluster of bad claims, and so it's something to get on top of right away. If an employee reports a claim, even if it's legit, again, cut finger, whatever, broke, badly sprained knee, something like that, and they report it 5 or 6 days after it happened, or even a few days after it happened, it goes back to, you need to watch it and be aware of it. It's different than all your other claims, right? If they refuse to see your doctor, or if they initially go to their doctor, so their private insurance company, their healthcare doctor, and receive treatment there, and then come back to you and say, well, it happened at work, those claims, even though they in some cases are just innocent mistakes, very often that employee is staging themselves to avoid kind of being one of those legitimate claims that we saw in that box,
Okay.
that box earlier.
All right. Anything else on this that you want to talk about, or should we move
No,
on?
I mean, again, it's some are more common sense. If your supervisor or you interview them and they have some timers, sometimes they remember what happened and sometimes they forget. That again, usually if you have a serious injury, you know what happened.
Yeah.
You know when it happened, how it happened, where it happened, who was there, all those things.
Right.
So if the story varies, or if there's forgotten pieces or whatever, again, red flag. Just be on top of that and engage your claims adjuster.
So in talking to clients, I keep hearing, the words risk management and cost control. And, my business, because we're an office, we have outside salespeople, we have inside people, we don't have manufacturing, distributing, and machinery and what have you. But what's the difference between risk management and cost control?
So I think the easiest way to picture it is that risk management measures are things that employers should do before an injury occurs, and cost control measures generally are things that employers do after a claim occurs. So a couple of examples of risk management, what we call techniques or approaches, or avoidance and contractual transfer. So if you've got a situation within your organization where you continually have injuries occurring, or there's really great potential for a serious injury occurring, you can either just stop business, not always, but you can at least evaluate the potential and the possibility, just not doing that operation anymore. Take that product line off, change a process, stop using a certain chemical, those types of things. And alternatively, you can also transfer that risk by having a subcontractor do the work. So maybe you have a plating operation and that's causing you problems or heartburn. You can hire a plating company and start shipping your stuff out. May not necessarily reduce costs, but it's a risk management measure, again, before a claim occurs, to address a problem that may ultimately cost you more than sending it outside. Okay. Obviously, the things that most people think of are loss prevention and safety measures, and then again, a proactive thing that companies can do that kind of crosses the line between cost control and risk management is putting in a thoughtful, customized employee incentive program to ideally promote safe work practices and not hide injuries, and keep safety in the forefront of your employees' minds, again, before they get hurt.
Okay.
Right. Cost control, again, is things that you would do as an employer after the fact. So medical provider networks, all of your employers, when you have new hires coming in, should be sitting down with the employee as part of the onboarding process, explaining what the MPN election form entitles the employee to, and having them either sign off on it and not pick a doctor, or if they do pick a doctor, help them really understand what that means. If you do that and a claim occurs, you more or less have medical control, you're in your carrier, you can send those employees to your doctors within the MPN network. Obviously,
And that's one of the forms that we see in a new hire package missing a lot. They don't have the form that says, here's our work comp carrier, and here's how much we pay you, and here's when we pay you. And then the follow-up is that personal physician designation form, which is what you're talking about.
mm-hmm.
But that form, how often do you actually see people choose their own doctors for that?
Almost never. And when they do, it's usually for one of two reasons. One is they don't understand and they have a doctor who they see for their personal stuff. And so they say, I go to Dr. Smith. Well, it turns out that Dr. Smith is a general practitioner who has no certification to do workers' comp. And when you explain that to them, they say, oh, didn't know. Okay, fine. I'm okay going to. The other reason is that they might have a situation, cardiac condition, let's say, and if they go down on the job, they don't want to be taken to the urgent care center. They want people to know that they need to get a hold of Dr. So-and-so to take care of them.
Gotcha. Okay. So other cost control methods, it says select and coordinate services, and I don't know what ICC means.
Right. Okay. So again, this is something a broker should be educating the employer with. The broker should be kind of teaching you these things. An ICC is an industrial care clinic. For sake of space, I shortened it down, but kind of cycling back to the MPN, within your MPN network, there should be multiple industrial care clinics. Sometimes geographically it's tough because you may only have one in the area, but assuming that you've got more than one, they vary. Some of them are big national firms, others are small local firms. They have different levels of service, they treat patients differently, so on and so forth. So again, this kind of also cycles back to risk management, but you should have, for cost control purposes, you should have selected a industrial care clinic that fits what your needs are and that you can work well with. So there's a whole program I have on how to select an industrial care clinic. Once you've done that, you need to meet with them and create a partnership. They need to know who you are, where you are, what your business is. In an ideal situation, they would actually come out to your facility, the physician and probably the office, the manager come out, meet with you, do a walkthrough of your facility, understand some of the claims you've had in the past. And then the final, most important thing is that you, as the insured, as their customer, you want to dictate to them how they communicate with you after they've seen your employee, and also what they do once they've seen or when they see your employee. And again, another whole program could be done on that. But doing those things, having that relationship, making the right choice of a carrier or ICC that works for you, and having them understand your needs and desires goes a long way to reducing costs when a claim occurs. The second item there is carrier claims handling. This really is something more for large premium companies over, let's say, $250,000 in premium. They should be, again, working with their broker to establish what I call special handling instructions or agreements with the insurance company, such as instead of having multiple adjusters on large claims, you have a dedicated adjuster that you meet. They come out, they meet with you, you only work with them. They know your claims, they know who you are, and so on and so forth. That you have say or at least notification prior to any settlement offers being made, so that you're not kind of caught off guard. But so, things like that. Do regular claims reviews. Even if you're a small employer and you've got claims, you should be following up at least on a quarterly basis, having a conversation with the claims adjuster that you're working with, again, ideally with broker involvement, so that they know everything you know, you understand what they're doing, you establish kind of next steps and timelines, and you push the claim forward. You kind of you don't browbeat them, but you want to make sure that they're doing their job and that your claim is at the top of that stack and getting worked. Okay. And then last thing on here, just two things actually are real important here. So we're going to slow down a little bit on this. Once an injury occurs, especially a very serious, legitimate injury, It's really important in the context of reducing the ultimate cost of that claim to the company to have a pre-planned employer injured worker outreach process or program. There's a myriad way of doing those things, but when somebody's seriously injured, their family is impacted in a lot of different ways, and they get very emotional. So they need somebody to be in touch with them immediately. Don't wait for the claims adjuster. Sometimes that'll take 2 or 3 days before the adjuster actually gets a hold of somebody. Get in touch with the family members right away. Explain what their workers' comp benefits are. Explain that they're not going to get buried under medical bills, and that if they receive a bill from the hospital or a doctor, that they are not to pay that bill. They're to forward it on to you so that you can get the insurance company to pay.
So you want to be a friend and advisor to the family,
right,
and make them feel more comfortable.
Yep, and not just in the beginning, all the way through the claim.
Okay.
And then last thing, build a team. Again, no matter what your size, have inside people that are assigned to do workers' comp claims. Have a good broker that works with you, educates you, helps you. Have them bring the carrier in and get as much carrier support as you can. And if the claim is litigated, again, there's ways to work with their attorney, essentially your attorney, that's selected by the carrier, and make them part of that team.
Okay, we're almost done, but we have about 10 minutes to go, and I want to make sure we get everything in. These are 10 steps to manage costs. And the first one is select and hire a good broker as your partner, which I would always agree with. But in work comp, it's even more important. So maybe, Paul, you can explain why.
Okay, so let's go with the worst thing you can do. I think especially if you're a company that has a history of workers' comp claims, legitimate, embellished, or fraudulent, or all three, and you have a tough work environment, the worst thing you can do is each year have 2 or 3 brokers go out into the marketplace and chase carriers or fight over carriers and try to get you the best price. Because what you're doing there very often is you're letting the marketplace pick your broker. So if broker B happens to get to the hot market, granted they get the better premium than the others do, but that broker may not be qualified and competent and capable and committed to helping you address the real issue, which is not your premium, but the problems that are driving your premium up. So what I suggest is well before renewal that you go through a broker selection process, involve 2 or 3 good brokers, maybe get references and so on. Sit down and find out from them what it is that they do to help their clients. First, put in place processes and procedures, and then how do they work with them after the fact to be engaged, be involved with the ongoing management of the workers' comp in its entirety, basically. That same broker, too, if they're a good broker, should also talk to you, if you're large enough, about alternative funding approaches. I told you a story earlier about a client that had historically had lots of smaller claims that were beyond first aid claims, but most of them were never really large. And so they chose to go with a low deductible program, $35,000 self-insured retention, essentially a deductible, where they paid all claims up to that amount. And in that structure, they also had some say as to what settlement offers were made, how much the settlement offer was going to be, so on and so forth. So they were, and for doing that, in this particular client's case, they saved $200,000.
So essentially, they self-insured for the low stuff,
yeah,
and,
exactly.
and took control of it.
Right, and because of the reduction in premium, they literally, their premium was $200,000 less. They saw it as, we have $200,000 in the bank to make those payments, before it costs us anything. So there's creative ways, especially for larger premiums, to reduce cost.
We talked about understanding your XMOD and how it's calculated and picking the right carrier based on your industry and your situation. But what does build comprehensive job descriptions mean to you?
So to me, actually, let me back up for one
second
second on the pick the right carrier. This goes, every employer doesn't have the same workers' comp situation, but every employer has to have workers' compensation insurance. So if you're an employer who's got a 60 XMOD and you virtually never have claims, then you should pick the carrier that maybe doesn't have a lot of services and that isn't customer focused, but is very price competitive.
Okay.
Because you don't need those things.
Right.
Conversely, as I said earlier, if you're an employer who really needs help and service and hands-on relationships, then picking the cheapest carrier that doesn't have any services is not the right carrier for you. So,
Gotcha.
Right. So back to the job description. So it's a simple thing, and it sounds silly almost sometimes for the size, certain size companies, but so many times I see that companies don't create really comprehensive, detailed job descriptions, especially for their most hazardous positions within the company. The reason for doing that, there's lots of them. In the interview process, obviously, you can ask an employee to understand this is what you're going to be doing. If you're doing pre-employment physicals or pre-offer or post-offer physicals, you can provide that to the physician, those descriptions to the physician, who can dig deeper into, are you physically capable of doing all the things that you're going to be doing in this particular job.
Right.
Conversely, the injury, an employee is injured, and the doctor has that detailed list, and the employee says to him, he asks, how were you hurt? And he says, well, I bent over and I picked up a 100-pound sack of flour. And the doctor sees the job description, and the most that person lifts is 25 pounds. Again, red flag. Is this a legitimate claim? Is this guy going to try to play the game? So there's all kinds of reasons, and very often employers just don't take the time to do it. And as part of that, they also should be kind of complementing those job descriptions by doing a thorough job station, job safety analysis on those key areas, where they watch the employees do the job for a long time, different employees and so on and so forth. And it helps them identify all sorts of things. What certain people are doing that unconsciously that are potentially going to cause them to get injured, or for new hires, knowing what areas are the most risky things that they should be aware of, those types of things. So.
Okay, I want to just make a point. It's almost 11 o'clock. We usually try to do this in an hour. We're going to go over. If you have to go, we understand. If you want to stay on, stay on. We only have about 5 more slides, and I want to make sure that we cover those items. They'll be on the recorded webinar. So on that note, we're going to talk about something that Paul and I talked about a couple weeks ago, which are industrial athletes. And I had no idea what this title meant. So Paul, why don't you talk about protective measures to protect your athletes?
So I can't take credit for this. I somewhere along the way heard somebody use the term industrial athletes. But if you do think about it, the people who come to work for you every day, most of them are performing some sort of physical activity for you. And so if you want to take the giant leap, they are essentially athletes. They're much like athletes. They come to work. Sometimes they have aches and pains. Sometimes they have previous injuries. You're putting them in an environment where they could become injured. You're asking them to do things that might cause them to be injured. So you take the concept that, or kind of think of the concept that you're going to treat them similarly to the way an athlete might be treated by the team they play for. I think it kind of puts it in a positive light, as opposed to just seeing them as folks who come to the office and do stuff for us.
Gotcha.
Right? So the first thing is, always focus on improvement in your work to help your employees be safer in the way they do things. You do need to have enforcement and not consequences. There needs to be enforcement and I guess consequences for actions, but the focus shouldn't be on punishing the employees when they don't do things right. It should be on getting them to
educating them as to how to do it.
Right.
And help. And the second bullet point is asking them input on how to do it safer.
Yep. And you'd be amazed how many times employees, when you go to them and say, what are we missing? Are we missing anything where you feel like you might get hurt, or we've seen where other people can get hurt that we haven't seen? How much they like the idea that they can be part of the process.
Yeah. So these bullet points you're basically saying is enlist the employees to help you make their job safer.
Absolutely. Okay. And so the third bullet point there is encourage your employees and empower them by making it okay for them if they see another worker doing something, let's say you've got somebody climbing up, 4 racks up trying to get something out of, out of the parts department, that they would go over to that other person and say, hey, you're not supposed to be doing that. You're going to get hurt. Let me help you, whatever that is. That they shouldn't just walk by and say, it's none of my business.
Gotcha.
Right. So
Yeah.
that they then become kind of the eye, have a safety eye, if you will, and do that for you. Supervisors in particular, where it says train your supervisors and make them daily ambassadors. It's critical that your supervisors understand what your safe work practice philosophy is, how to impart that message to the employees, and that they do it regularly, and that when they do find themselves in a situation where they have to come down on somebody or correct somebody or whatever, that they know how to do it.
Okay.
And that they're out there. The loss control guy from the carrier can't be on your floor or can't be in your office every day. The manager very often is off doing other things. People who are directly engaged with their employee, the supervisors, they're in many cases the pivotal player on your team that makes or breaks your safe work practices.
Okay. So what I'm basically getting is educate your employees, coach them, have them help you figure out how to do things safer, and keep the environment friendly and communicative, so that they can help you and lower the potential safety issues.
Agreed. And I like the picture you put up there. And something I missed is when you're imparting that safe work, that philosophy, back to the industrial athlete, they're part of a team. They all work together at the same company, ideally for the common good of the company, and being supportive of each other. That you make them feel like it's a team effort to keep everybody safe and to make sure everybody goes home with all their their fingers and vision and everything else.
Right. Okay. Moving on.
I think most employers know this, so we can kind of breeze through this. But the things that I see regularly that are causing claims that either are legit or embellished. One of them that we're seeing more and more is repetitive motion, not necessarily in the workstation on a production floor, but in the office. So you mentioned clerical earlier, the class code. There are so many injuries that are legitimate and significant that occur in a clerical environment because of lack of good workstations, lack of proper equipment, people not getting up and taking breaks, so on and so forth. So when people hear repetitive motion, they always think it's somebody doing something with their hands on a production line. But an office environment, and if it is ripe for those types of things. And if you're a company that has clerical as your main code, and you have a large claim, your XMOD goes through the roof and your premiums double almost overnight. So It's really something to get in front of by doing ergonomics work on the front end. And then the others are kind of common sense, slips and falls, bending, that sort of stuff.
Okay. So carrier claims management.
So this kind of circles back a little bit to some of the things we talked about earlier, but a lot of my clients and a lot of business owners and companies are unaware of this, and it's important. Within an insurance carrier, there are different departments that handle different types of claims. So if you have a medical only claim where there's going to be a medical bill, the employee didn't miss any time from work, and it's going to be kind of a turnkey, it'll be closed in a few months and be done with it. Those claims go to one team of people who tend to work in volume for obvious reasons. Those adjusters don't see big claims. They only see med only claims. Okay. Then when an employee misses time from work and is going to get temporary disability, that claim is handed off so they all start in the medical only department, right? Even if you know the person's going to miss time. Then they're handed off to the indemnity department, and those adjusters see fewer claims and generally bigger claims and more sophisticated claims. All right, and they handle the claims differently. And then the third layer is when one of those indemnity claims becomes litigated, that case more often than not, once again, gets handed off to another unit that deals with litigated cases. The point of all that is that, again, you as an employer, if you know that somebody's going to be out of work because of what started out as a medical only claim. Let's say things get worse, they get an infection, they come back to you and say, I just kind of thought I tweaked my back, but it really is bothering me now.
Mm-hmm.
Get in front of that and call the adjuster who's got it and tell them that, so that it more quickly gets to the indemnity person. In a perfect world, you would find out who the claim is assigned to and start having conversation with that adjuster.
To speed things up.
Yep.
Okay.
And if you know that they've gotten an attorney, or even if you've heard that same story, you and that indemnity adjuster want to get in touch with the litigation unit and get it fast tracked so that it doesn't have time to kind of not be overseen.
Right. Okay. Abuse reduction.
Yeah. So, this, maybe we can kind of go through this quickly. It kind of goes back to some of the things we talked about earlier, and I'd kind of go down to the bottom for sake of time.
Okay.
Again, we talked about always doing that accident investigations, whether it's a near miss or a serious injury, and have a process to do that ahead of time. Know who's in charge of it, who's going to do the interviews, how they're going to do the interview, so on and so forth. So you're not making it up as you go. That'll go a long way. When an employee knows that the employer is really going to be on it, and that they're going to have to tell their story to multiple people, and that they're going to talk to their coworkers, so on and so forth, it can only help to deter their desire to take advantage of things. And back to the employee outreach, the legitimate worker who wants to come back to work, help them, give them every reason to stay away from an attorney. And then finally, just something that a lot of employers don't consider because they think it's too expensive, but they very often should. Consider doing post-offer physicals for employees that are coming in to fill certain positions. Very often, back to that good relationship with your industrial care doctor, they can, again, you can't not hire somebody for a physical problem, but they can also just give you a heads up on things that you may want to know about an employee ahead of time, and that they can ask them questions like, do you need accommodation coming in, and so on. Two more kind of quick things that again, these are topics for other presentations, but putting in a camera monitoring system, especially in an industrial application, is a really good way. Back to, if employees know that somebody's watching, or that if they do try to stage an accident or whatever, that it's going to be on film, it can only help to reduce the potential for that. And then lastly, financial accountability. It's amazing how effective it is when companies hold their supervisors and managers financially accountable for comp claims. If their bonus is reduced because multiple people had injuries in their department, back to that being the safety ambassador, it's going to be front of mind for them and not tucked away in the back.
Okay, and then the last one, accident investigation, and these are kind of review of things we've already covered, but I think it's a great summary. Starting out with, investigate every injury in the same or a similar way. So basically you're saying is have a process.
Have a process, and don't pick and choose, because what you don't want to do is make it appear that because that claim didn't pass the sniff test, that you're kind of picking or singling out that particular employee where they can allege discrimination or retaliation or whatever. So if you're consistent, at least relatively consistent in how you deal with all of your claims, it protects you, basically.
Okay.
Again, these are kind of, without going into a whole kind of process of how do you build an accident investigation process, there's some bullet points in here, and
that are important to have.
Yeah, and maybe someday we can do this again and kind of get more into the nuts and bolts of all this.
Yeah, I want to finish today, and I want to thank you, Paul, for presenting this. I think it was very informational. But recognizing that being proactive is really important, and we have a client that works with supermarkets and food restaurant chains around the country that have 100 locations or more, and they basically are selling safety products to these companies, like cut gloves and shoes that don't slip, and certain types of products that'll make those restaurants and those supermarkets safer for the employees. And what they've done over the last 10 years is gone away from dealing with purchasing and moving it to risk management, because risk managers in larger companies are the ones that see the work comp bills, they see the claims, they're trying to lower that. And so these companies are being proactive in helping their employees avoid issues. And I think that's one of the things I learned from Paul was, get your employees to help you make things safer, help them be educated as to how to do things safely, and that lowers your risk, and that's very important. So again, and then I'll put the last slide up here, is we're always a great resource for compliance information and labor law and things of that nature, but Paul is an expert in property casualty and obviously in work comp. So here's his contact information. We will get the recording out in the next week to everybody, and also get the slide deck out to everybody also. So thank you again for attending. Just as a reminder, next month we're going to be having a webinar with Sherry Shavit of Tharp & Howell. She heads up the labor law department for Tharp & Howell, and she's going to do a presentation on what you can ask employees when you hire them. She did a presentation to our Woodland Hills Pirate chapter last month. I know Paul was there. She's an excellent speaker. She's does the webinar for us once a year. So she'll be going in October. So be on the lookout for that. Thanks a lot, everybody, and have a great day.